matter of the marriage of Tyler Medkiff versus Katherine Medkiff. The petitioner appears with his attorney, Ms. Cooper. The respondent appears with her attorney, Mr. Andrews. Mr. Andrews has filed a motion and citation for contempt, and then actually filed an amended motion for contempt. It's alleged that petitioner has not paid child support as directed, and he's in arrears, and that he is behind considerably on the house payment or mortgage, and it is about to go into foreclosure. Ms. Cooper, have you had a chance to review these allegations with your client?
Yes, Your Honor, and there has been some recent developments that changed the situation significantly. I can let you know now if you want.
Okay, yes, please.
Okay, thank you. So the house was sold yesterday, so the mortgage has been satisfied.
All right.
That part is out, and Josh Andrews and I have talked about that already.
Okay.
Ms. Metcalf had signed on September 17th an affidavit of non-arrearage, indicating that my client has caught up and wasn't behind in anything. I have since spoken though with Mr. Andrews about it, and there was a first payment due in March of 2025 of $1,200 before the income withholding order went into effect. Mr. Metcalf attempted to pay that by check, mailed a check to the Kansas Payment Center, but it was issued in written out to Respondent as opposed to Kansas Payment Center like it should have been. So that payment, we acknowledge, has not been made at this point. He does want to, he understands he's obligated to do that. He would welcome an opportunity to make payments to catch up on that. There might be an additional issue. Mr. Andrews indicated he would talk to his client about it, where child support might need to be modified. We don't know at this point. If it does need to potentially get lowered based on current incomes, that might help him get caught up on that $1,200 quicker, but I don't know the numbers on that. So what I was suggesting is maybe we could run a new child support worksheet with new income information and go from there.
All right.
Oh, there's one other thing, sorry. Judge, I don't know if you recall, but in the journal entry and judgment and decree, you had indicated that Respondent would be obligated to pay my attorney's fees to prepare a quadro, or part of my attorney's fees in the amount of $500. She hasn't done that yet. I've discussed with Mr. Andrews the idea of him completing the quadro now that he's entered. She didn't have an attorney at the time. I think we both agree that makes more sense.
Okay. Great. Mr. Andrews?
Your Honor, I have not spoken with my client regarding whether there's been a change in her income that would justify a modification of child support. I've also not spoken with her about the quadro issue because neither of those were part of our motion, and there's no motion to modify child support on file. I will be discussing those issues with her, but for purposes of today's hearing, I think that I first would agree that the issue regarding the non-payment of the mortgage has been rendered moot by the sale of the house. So we're not seeking any relief on that issue. With regard to the child support and spousal support arrears, there is an income withholding order in place that withholds weekly, so it makes the calculation of the arrears number not 100% accurate based on the fact that, for example, there's presumably going to be one more payment coming in for the month of September.
Okay.
So the arrears through today is $1,254.55. However, I think it's pretty easy to determine what the arrears is just simply because March did not have any payments and the income withholding order started in April. And so what I would just be asking is the court to determine that Mr. Metcalf still owes $1,200 total for the month of March, and just ask that he either pay that amount in full or an additional amount be paid each month at the court's discretion regarding the amount to satisfy that arrearage. If and when child support is modified, then the arrearage, the amount being paid towards the arrears can be modified as well. But I don't think that we're even, we're not even in a position to know whether that's even going to happen. And so I think that it'd be better just to establish an amount to be paid to satisfy that arrears going forward.
So, Ms. Cooper, when he sold the house, did he not walk away with an extra amount of money at all? Anything?
No, it sold to pay off the mortgage. That's all.
Okay.
I think, I don't know if the court remembers, but both parties were concerned back in January, February, when we had the trial, that there was a possibility he would have to pay in at closing as opposed to netting anything. But it worked out even.
All right. Well, I remember that's why he got back into the house, because he said he fixed stuff up without paying someone to help sell the house to, get them out of debt. But I was just thought by chance something may have happened that gave him a few $1,000s from that sale, but apparently not. So, I mean, there's no doubt in my mind he needs to make at least an additional $100 a month payment to pay off the arrears.
Okay.
All right, sounds good. And let's get that quadro taken care of. So either, I suppose one thing is he could pay you $500 to do the quadro and take that off his $1,200 that he owes, or she can owe you nothing and Mr. Andrews can do it. However you guys want to come up with that. But I'm not seeing here that I need to schedule another hearing right now anyway, until something else develops that the attorneys want to request a hearing.
I would agree with that, Your Honor.
Okay.
Me too.
Okay. All right. If there's nothing further today, then we are adjourned. Thank you, counsel, very much.